So there are several statutory grounds for divorce in Georgia. The most common ground that you've probably heard of is irreconcilable differences, which basically means that you guys just don't get along anymore. Aside from that, there may also be adultery, which can be a grounds for divorce. There's also cruel treatment, which can sometimes go hand in hand with adultery as well. And some of the more less common ones can also include abandonment or habitual intoxication. But the number one grounds is definitely always going to be irreconcilable differences. As it relates to which party files first in Georgia, my personal belief always is there isn't really an advantage. If you have an attorney that knows what they're doing, then that's the advantage. There are some differences as it relates to if you are the plaintiff slash petitioner or the defendant slash respondent. So, for example, if you are the plaintiff, which means that you file first, then that also means that you get to present your case first. So that means that your witnesses can go first. You get to choose who goes first. You can even choose if you want to go first or last, or both in terms of closing. So Georgia is what is known as an equitable division state, right? So what does equitable mean? It means what's fair. So a lot of people get confused and think that Georgia is an equal state, which means 50-50. Now, sometimes equitable could be 50-50, right? But like family law in a lot of cases that I deal with, that's not always the case. Right. So, if, say, for example, you have a case where one spouse has been cheating and they've been taking their paramour on these expensive, lavish trips around the world, right? So, they're spending all this money on them, buying them gifts, perfume, expensive dinners. So the whole time that they're doing all this shopping, they're depleting what's considered the marital estate. So once it comes down to it, when it's time to divide those assets, a judge might say, hey, you've used up all of your money entertaining this third party, so we're not going to divide this 50-50. We're going to do it equitably. So in that sort of situation, it could look like 70-20 or something like that. But if you are fortunate to have kind of a more simplistic divorce where it's like you're just not getting along, then a judge might say, well, what's equitable is to do it 50-50, which would be the same as equal. So, alimony, the way that I like to always refer to it as, is it's basically financial support for the spouse, right? There's a stereotype that only women are entitled to alimony, but that's just not true. Alimony is going to be something that the less earning spouse would be entitled to if, say, for example, they're just not having the same earning capacity as their spouse. Now, there's no case law as to how alimony should be awarded, but the way that the courts generally look at it, they're going to look at two factors, right? So they're going to look at one, does a spouse need the alimony? And two, can the other spouse actually pay the alimony? Right? Because if we're looking at a situation where one spouse is like, well, I think I deserve alimony, but then the other spouse is only making $20,000 a year, then realistically, there's no money there for alimony. So it's not going to be awarded. When I see alimony awarded, it's typically in situations of, say, for example, one spouse is a stay at home parent. So they're a stay at home parent for, say, maybe 10 years. So during that time, they have no work history, they have no education. So once the divorce is said and done, the court needs to look at, well, how are they going to phase into a life and sustain themselves and their debts and their expenses if they do not have that earning spouse in the picture? So then in that case, they will award some sort of alimony so that they can essentially phase themselves into that single life. But it's not going to be for a period of eternity, except if you were married for a substantial amount of time. It's really just to kind of give you that cushion so that you can adjust to what a new life would look like without that additional income. So, in regards to child custody, that's obviously probably one of the biggest issues that we deal with in family law. So, there are two types of custody. So, it's legal custody and then it's physical custody. So, legal custody is essentially who has legal rights to the child. Right? So, who would have access to the medical records for the child? Who would have access to the school records for the child? For the most part, that's always going to be a joint legal custody type of schedule. The only exceptions that I've seen to that would be if one parent is incarcerated, for example, or if one parent is just not competent. to be able to have those rights. Like, for example, they may be addicted to some sort of drugs or they may have some sort of severe mental illness. So, those are obviously extreme examples of when a parent would not have joint legal custody. As it relates to physical custody, there are mainly two types of physical custody. So it's either joint physical custody schedule or it's one schedule where one parent is a primary over the other. If parents are going through a joint physical custody schedule, that means they're literally going to be joint. It's going to be 50-50. That means that the child is with one parent 50% of the time, and then the child is with the other parent 50% of the time. So that type of schedule can usually be a week on, week off, or it'll be a schedule where they will alternate days. So what I frequently see in my line of work with a joint physical schedule is that one parent will have maybe, for example, Monday and Tuesday, then the other parent will have Wednesday and Thursday, and then they will alternate those weekends. Now, the most common schedule is where one parent is a primary physical parent, which basically just means that the child is with them most of the time. So in that case, the non-primary parent, they would get the child, say, for example, every other weekend. But what does that look like? So one of the things that I like to tell my clients is that family law, it's not cookie cutter, right? Everyone's family is different. So I always like to encourage parents to look at, well, what would work best for you? So for some parents, depending on where they live, if they're close together, they could perhaps do maybe a Thursday to the return to school Monday, right? And then that would give them just a little bit more time, but it's a little bit above and beyond what some people would consider a weekend. For other parents, that might not be feasible because, say, for example, maybe they live 2 hours apart. Then they might do something where it's an after school Friday, they will pick up the child, and then they'll return them Sunday, maybe in the evening, so that they can settle in and get ready for school on Monday. So that's definitely something that changes depending on your individual circumstances and what would work best for you and your family. So, in a nutshell, that's probably as simple as I can break down how a divorce would work. If you have any further questions, feel free to reach out to us here at Daniels and Taylor.